And that case is State of Ohio versus Robert Pari. Both sides will have 15 minutes to argue. This appellant may reserve up to 5 minutes for rebuttal. If you are the appellant in this case and wish to reserve any time for rebuttal, if you let me know when you get started, I can let you know about the passage of time. The court's read the briefs. We're ready to proceed when you are.
I'd like to reserve 2 minutes if I may, Your Honor. If it pleases the court, my name is Mark Ludwig. I have the privilege of representing Mr. Pari by appointment of the trial court after the prior appellate counsel had to withdraw due to health reasons, and I saw her yesterday. She's fine. It's nice to see she's back. This is, for shortness of form, this is the fanny pack in the truck bed case. It certainly doesn't hold the interest that aggravated murder cases do, but on a day-to-day basis, it's got some points that are pretty important. My client was charged with aggravated possession of drugs and a drug abuse instrument, some syringe. All of this stuff is found in the fanny pack in the truck bed. Now, there is only one witness in this case, a state trooper's office, and after 25 years of having the privilege of representing the state of Ohio on behalf of the village of Peninsula, I generally am very highly impressed with what the State Patrol does. This officer could have been better in this case. We have 4 assignments of error, manifest weight, and sufficiency. We'll talk about those together. We have a charge of a question on the jury charge on constructive possession, and of course we have the sentencing question. Now, this is not a case where the drugs are found on the person, or in the driver's seat and the defendant's the driver, or in the passenger seat and the defendant's the passenger, or in the back seat behind either one of those, or on his person after he's out of the truck. These drugs are found in the fanny pack, which is in the back bed of the truck, outside of the passenger compartment. The court has photographs it can look at.
Who owns the truck, counsel?
Oh, the truck was owned by my client, and the evidence was fairly clear. He'd been on his motorcycle. He is at a bar. He has probably too much to be getting back on his motorcycle, and his designated driver was of no help in the long run.
There were motorcycle goggles found inside that fanny pack, correct?
There were, and that's entirely consistent with coming out of the bar. You got your motorcycle glasses with you, and you throw them in a bag. Doesn't mean you threw them in your bag. There were also syringes found in it.
I'm not sure that somebody that's an avid motorcyclist would agree with you that you would just be throwing your goggles around anybody's bag, but what was the evidence in regard to that?
Well, the troop originally said that the co-defendant said to him during an interview, in his report, he said the co-defendant said that the glasses and some of the other items in there, I think there were prophylactics and one other item, that those were Mr. Pari's items. She did not, in terms of the report, say anything further. At trial, all of a sudden, the troop added, oh, and by the way, she said everything in there was his, including the drugs. Interestingly, the syringes in there certainly didn't match up to any observed marks on my client. The troop did note that the driver, the designated driver, had a series of injection marks on her and apparently had a history of drug abuse. No such thing on Mr. Pari.
Well, he wouldn't have to be using it to be found guilty of the charges which he was found guilty of.
No, but in terms of the evidence of the inference of who those syringes might belong to someone with a history of track marks on their arm is probably a better bet than somebody who's clean at that minute. That doesn't mean that you've never injected before, but it's a piece of evidence.
You mentioned, I think, that you said that she didn't testify, but the driver, the female driver, only referred to, like, the condoms in there and something else, not the drugs, correct?
In the report, that's what the troop wrote down in the report. When he goes to testify, he then says, oh, she said everything in there was his. But I didn't note that in my report. And he was crossed on that subject as to, don't you try and include important things in your report, and no, I just forgot that.
Well, counsel, speaking of the condoms, since apparently I was, when you started saying this trooper could have done more, didn't the trooper, like, go online, match the lot numbers of the condoms, the expiration date, check with the website?
Yeah, he did. He did, yeah.
What more could he have done?
I don't know that the fact that there were condoms in there proved that they're his.
How about the fact that a matching one was in his pocket on his person?
You say matching because the troop says he did all of these things to
That's
say.
why I say matching, yeah.
That still doesn't say that it's his condom. He might have obtained it in the intent of use from someone, so it doesn't necessarily mean it's his. I think it's important that, you know, we've got an officer who testifies, and an experienced trooper, who says I stopped them for a traffic violation, loud muffler, and changing lanes, and oh, by the way, I didn't write them for that. I did, after I had them out of the truck and under control, I did what was called a probable cause search of the truck. Now, in terms of the manifest weight, the objective evidence that the troop said he saw was a dot of marijuana on the passenger seat. And the dot is his words.
Excuse me, counsel, we're not talking about suppression issues here.
No, we're not. Suppression was not filed, but we are talking about whether or not we're going to get to constructive possession fairly. And I think this factor is what gets you to constructive possession fairly. I submitted, he had very able trial counsel. And I suspect the decision whether or not to file suppression is a tactical decision that was made not to do and to stay with the constructive possession argument. And I have no problem with that. I have the problem with that the constructive possession argument in hindsight didn't work because of the jury charge in this case. The trooper testified that there was this dot of marijuana, that's why he had to do his probable cause search. Unfortunately, when this court reviews the, or fortunately for us, when this court reviews the pictures, you'll see that there are no, you can't see the dot of marijuana. And remember, the search is conducted after everything's taken out and put back by the troop. That's what he says. The troop was certain that it was my client's fanny pack because of the dot of marijuana on the passenger side. And that's 153 and 194 of the transcript. I don't know how that makes the fanny pack yours because of the dot of marijuana. And it did say that there were goggles and a phone charger in there. The phone charger, the phones, none of those are admitted in evidence, but they're talked about as, gee, the phone charger matches up to his phone. Nothing's in evidence.
It was a flip phone, correct?
That's what he said, yeah. And again, the argument is made that it would only fit his phone. Well, it's a wonderful argument to make, but you don't have the physical evidence there, one way or the other, to talk about. The troop also said at 2:05 that he assumed the phone cord was Robert's. That when he saw the needles, he also had seen the marks on the co-defendant. And in terms of manifest weight, the state in closing argument says, well, this is at 295, the state in closing argument says, well, it was his truck. Well, again, a lot different case presented if it's in his pocket, if it's under his seat, if it's in the counsel near him. We're getting those kind of facts that warrant a constructive possession charge. But when it's outside the compartment that you're sitting in the back bed of a truck, and all it is that you own the truck, that doesn't make it your fanny pack. The Matson case that this court has cited before in terms of manifest weight is a fantastic case, cited in our brief, but it's a fantastic case for the standards of what this court uses on manifest weight of the evidence. And again, I know it's a tough battle. I know I'm asking you to sit as the 13th juror and assess credibility. Those things being said, do we have some incredible instances here? Factor number one, do we have uncontested evidence here? No, everything's pretty much contested. we have witnesses that are somewhat impeachable. And I think, with all due respect, the troop was somewhat impeached. When a troop of this experience doesn't note in the report that the co-defendant fingered the defendant and said that was all his or her stuff, and then says, oops, I didn't write that in my report, that's impeachable. I don't know many police officers that would forget that point in their report. What was not proved in this case was that Mr. Perry was anyway in charge of those items. To have constructive possession, there must be something beyond nearness to the object. A knowing exercise of dominion and control has to take place first before you get to a constructive possession jury charge. The cases that the state cited, the Reese case, for example, from this court is a great case because it's one person in a one-car accident. They find one pill after her purse spilled. Okay, well I'm willing to give a constructive possession charge in that case. That's not the facts of this case. Kendall is cited. A co-defendant says the defendant admitted all this stuff was his, and the stuff was found under the defendant's passenger seat. That, again, is probably a fair constructive possession case. That's not this case. Ruby, crack pipe is found behind the driver's seat. Driver's charged. Lamb case, trash. The officers approach. They see the guy walk by the trash bin in his house. They have a search warrant. They go in the house. They find drugs in the trash bin. Nobody else in the house. Might be a good constructive possession case. Williams, they search the house with a warrant. It's a solo owner and one person there. Again, might be a good constructive possession case. At some point, the word standard instruction does not mean you must always give it. That the facts have to support giving a standard instruction.
So counsel, are you arguing that the jury instruction shouldn't have been given, or are you arguing that it was an incorrect jury instruction?
It should not have been given, and that issue is clearly preserved by the objections of trial counsel, that it should not have been given in the facts of this case. And the best answer we've been able to get from the state at trial and here is, well, it's a standard instruction. Well, it's not a standard instruction when the fanny pack, who's got no identification in it, is in the back of the truck.
Well, that's assuming you don't believe the officer who said that the co-defendant told him that that fanny pack belonged to your client.
He did say that at trial, Your Honor. He said it nowhere else in his report. It is evidence, and that's why we raise it in the manifest weight for you to consider also, whether that truly is incredible.
And you're reaching to that rebuttal time. You may proceed.
Then I'll reserve my time for reply, other than to say, Your Honors, this case should be reversed. Thank you.
May it please the court, Heaven D. Martino on behalf of the state of Ohio, the appellee, we are asking that this court affirm the conviction for aggravated possession of drugs in violation of 292511 AC1, a felony of the fifth degree, as well as possessing drug use instruments in violation of 292512 and 1. With regard to the sufficiency and weight of the evidence in this case, with all due respect to appellant counsel's argument that this is not a case of constructive possession, this was the defendant's truck. When the officer, the state trooper, saw the driver of the vehicle making a traffic violation, the vehicle was pulled over. The driver did not make any movements. Ms. Pasco, was just in the vehicle, not making further movements. However, the defendant did make movements, did appear very nervous, was lunging around, etc. The officer noted that those type of nervous behaviors are what he has seen in his training and experience as being indicative of criminal activity. Ms. Pasco's purse, the driver's purse, was found in the car. It did have drugs and paraphernalia in it. That was not something that the defendant was charged with. What he was charged with was what was found in the bed of his own vehicle, which was a fanny pack, as the court pointed out, that had his motorcycle goggles. Based on the testimony of the trooper, there was a cell phone charger that matched the cell phone that was on the person of the defendant, which was a phone that the officer said he had not seen very much of. Again, as the court pointed out, there were condoms in the fanny pack that matched the lot number, expiration date as the condom that was found on Mr. Perry's person. Also in that fanny pack, in the bed of his vehicle, containing his goggles, etc., were drugs and a syringe. So this argument that because Ms. Pasco had track marks and Mr. Perry didn't, these things may have been hers, that is just, speculation and conjecture. Clearly, she had drugs and paraphernalia in her purse. She could have had the syringe in there if that was hers as well, but she didn't.
Well, I was just wondering, actually, I know, really, there's a concept of joint possession,
Correct.
and she could have been charged as well with that.
She could have been.
No, she wasn't, but I was going to ask your opposing counsel about that, and I forgot to. So, what would you say in regard to that?
She could have been charged with joint possession. Clearly, if she also knew that those things were in the fanny pack, I suppose. With the, as I understand his argument that was set forth in the brief, was more along the lines of, you can't make a constructive possession argument here because you can't show that my client knew that there were drugs in the fanny pack. So I assume that would be the same argument he would make against a joint possession argument as well. And while it is true, as opposing counsel indicated, that there was no variation on the constructive possession charge given, they simply didn't want a constructive possession charge. I'm sure they didn't, because this was a good constructive possession case that matched the jury instruction that is set forth in Ohio jury instructions. The fact that they offered no variation is, a problem as far as, what error did they preserve? What the standard is for jury instruction is that you review the instruction in the whole, and that the court's required to give an applicable, correct statement of the law, which the court did in this case. And when you add the fact that this is his vehicle, he had dominion and control over the vehicle, he only called for, someone to help drive the vehicle because he had been drinking. You've got his fanny pack. I don't know whose fanny pack counsel is trying to allude to that it was, that just happened to have all of his things in it, that he's going to admit there were his goggles and his condom and his phone and the charger to his phone. However, how did the bath salts and the pills get in there? Clearly, based on the facts of this case, there's circumstantial evidence, which is to be given the same weight as direct evidence, that these were his items. The trooper testified to it. There's not enough in the record to warrant any type of a finding that Sergeant Laughlin was not to be credible just based on one item that was not in his report.
Counsel, to that point, one of the things that kind of concerned me when going to the credibility was, and the defendant or the appellant mentioned it in his brief, and we haven't had the record read yet, and we will obviously, but we haven't at this point. So I don't know what is actually in the transcript, but the trooper supposedly admitted that he had worked 15 hours. He wasn't that clear in his head, and may have left some things out and all these type things. Doesn't that, even if it's just one thing though, doesn't that cut the other way too, in regard to now how many months later he's trying to remember and is already admitting that he didn't have a very clear head and he was very tired? So doesn't that go to his credibility?
That could go to his credibility. But however, the other things that are in the report, there are so many things that tie the fanny pack and the things in it to the defendant. I mean, how much more would have been in there if this officer had worked, a few hours? He did a good job, even if he felt he wasn't clear in his head. I think that, given the record and given the report and given the work that he did, matching the condoms with the expiration and the lot, kind of cuts too against, was he really doing, a job that he was foggy in the head? Maybe he might have felt that way, but in actuality, I think his work shows that he did a good job. And just, it's very, very hard to look back and say, oh, well, he left one, aspect of what a witness told him out of his report, therefore, okay, we're gonna throw everything out. He still included all of these other things. I don't think that there's really much basis, to even make that argument with regard to Sergeant Laughlin's credibility. As far as the construction possession instruction that was given, that is a correct statement of law. It complies with OJI. This idea that it's reversible error because the appellant offered no variation, that is not a proper, I guess, standard of review. If they disagreed with the constructive possession at all, then that's fine, but you can't argue that the instruction that was given was not accurate. It is an accurate instruction based on the law. With regard to the final assignment of error, that the sentence is contrary to the law, the state would just ask that this court modify the sentencing entry to reflect that there was no sentence that was imposed on the misdemeanor, and in the alternative, then it could be sent back for that to be done by the trial court.
I was going to question you about that, and actually, the appellant didn't get into this, but you as the state filed a motion to dismiss on the basis of the non-final appellate order, which is our case law in this district. Would you like to address that? Because now you're asking us to modify it. We have to have jurisdiction in order to modify it.
Right. And if this court is willing to find, based on the record, that in fact what the trial court did was impose only a sentence on the felonious assault and was finding that the misdemeanor was allied and not imposing a sentence, then this court would have jurisdiction. Or in the alternative, if the court finds that there was no sentence imposed and that that the court lacked jurisdiction, then we would still stand by that motion. But in the alternative, we would ask that the court go ahead and make that finding and amend the entry. And if there are no further questions, I'll rest on the brief.
Thank you.
Your Honor, please, the court, in terms of the jurisdictional issue, Your Honor, I've come full circle. Having studied Goodwin finally, and having written to the contrary, I think the well-reasoned dissenting opinion in Goodwin is a correct statement of the law. Remember, Goodwin is decided before Saxon is announced. And in Saxon, the Ohio Supreme Court did say, if there is one sentence imposed on multiple crimes, and this entry permits that reading, that there was one sentence imposed on multiple crimes. The trial court recited both convictions in the sense of jury findings, and then imposed a sentence, one sentence. Goodwin had cited Williams, which said, we have jurisdiction. And then Goodwin said, oops, let's go back to the older view. And interestingly, in Goodwin, the author of Goodwin recited that the panel members, 4 of the panel members at that time, had issued opinions. Well, I think if we look, there's those 4 panel members are no longer on the court. Now, I'm not a Gonzalez fan that in 1 month stare decisis goes out the window, but nevertheless, Williams did stand for the proposition that there was an appealable order, and Williams is good law. It conflicted with Goodwin. Things have developed sufficiently that this is a final appealable order. Constructive possession requires proof first of a knowing exercise, dominion, and control. What we find in Mrs. Mapp's trunk doesn't prove that we could break down the door. When we have no knowing exercise and control proof, we don't get a, quote, standard instruction. We get a possession instruction. If they'd only gotten the possession instruction in this case, we wouldn't be bothering this court.
And counsel, unfortunately.
Thank you, Your Honors.
Thank you. Thank you both for your presentations on this case this morning, soon to be afternoon. The court will take the matter under advisement, issue a written decision, which will be mailed to both sides as well as posted on the Ohio Supreme Court website.